Federal agents just lost control of the street. Here's the contradiction no one expected. A courtroom, not a protest, became the front line. In Portland, outside an ICE facility, federal officers were using tear gas and projectile munitions on people who were peaceful, on journalists doing their jobs, even with children in the crowd. And then a federal judge stepped in and said, stop, not quietly, not narrowly. Judge Michael Simon issued a temporary restraining order and opened it with a warning that sounded less like legal paperwork and more like a national alarm. He wrote that in a functioning constitutional democracy, free speech, nonviolent protest, and courageous journalism are protected. Then he added bluntly that the country is now at a crossroads. This matters to you because once a judge starts talking about democracy itself, the issue is no longer Portland or ICE or one night of clashes. It's about who sets the limits of power and what happens when those limits are ignored. And the most important part of this ruling isn't the restriction. It's what it signals next. What happened in court looks simple on the surface, but that's misleading. The ruling didn't come out of nowhere, and it wasn't about a single clash or a single night. The plaintiffs told the court they were gathering outside the ICE building to do three basic things: speak, report, and protest peacefully. Judge Simon quoted that directly, stressing lawfully and peacefully at and around the facility in Portland. Yet the response they described involved tear gas, chemical agents, and projectile munitions. This wasn't framed as crowd control during riots. It was framed as force used against people exercising First Amendment rights. And here's where the pattern starts to matter. This was a class action request, not an isolated complaint. And the judge granted a temporary restraining order specifically to prohibit excessive force by federal agents. Now notice the framing shift. The court didn't ask whether ICE could maintain order. It asked whether a democracy can tolerate normalizing force against peaceful protest and journalism. And once that question is on the table, the case stops being local. Because if this is lawful here, why wouldn't it be lawful everywhere? The judge made a claim that cut straight through the noise. This wasn't about restoring order. It was about stopping abuse. And he backed it with language that's unusually direct. In the order, Judge Simon wrote that the plaintiffs were seeking to exercise their First Amendment rights to speak, gather news, and protest lawfully and peacefully outside the ICE building in Portland. That line matters because it fixes the frame. Peaceful, lawful, protected. Then the ruling draws a hard boundary. Federal agents are barred from using tear gas and other chemical agents on those protesters and journalists. They are barred from firing projectile munitions at heads, necks, or torsos. The judge went further, spelling out that those areas could only be targeted if deadly force would otherwise be justified. Now pause on what's missing. There's no language here excusing chaos, no suggestion that officers can't respond to real threats. In fact, the judge explicitly notes that deadly force would be permitted if, for example, a protester raised a firearm. So if that safeguard is already acknowledged, the question becomes sharper. Why was this level of force being used in the first place? What makes this escalate isn't just the order, it's the tone behind it. Judge Simon didn't write like someone settling a routine dispute. He wrote like someone responding to a pattern that's becoming familiar. Early in the opinion, he contrasts two systems without naming them directly. In a functioning constitutional democracy, he says, free speech and nonviolent protest are respected. In an authoritarian regime, they are not. Then comes the line that changes the temperature of the entire case. Our nation is now at a crossroads. That isn't legal housekeeping, that's historical framing. Courts usually avoid that language unless something has already gone badly wrong. And this isn't the first time judges have stepped in when federal force starts to feel normal. History shows the same cycle. Aggressive tactics justified as temporary, exceptional, necessary, until they're no longer exceptional at all. What's unsettling here is how calmly this force had been deployed, as if tear gas and projectiles around journalists and families were just part of the landscape. The ruling pushes back on that normalization. It signals that something once treated as routine has crossed into unacceptable territory. And when a judge starts drawing lines like that, the story stops being about crowd control and starts being about precedent. The second hit of evidence is harder to ignore because it exposes a contradiction. Federal authorities often say these tactics are defensive, restrained, and necessary. But the judge points to incidents where peaceful protesters were gassed anyway, including situations involving children. That detail appears in the order for a reason. It breaks the narrative that force was narrowly tailored or unavoidable. Judge Simon doesn't just describe what happened, he limits what can happen next. No chemical agents on peaceful crowds, no projectiles aimed at heads, necks, or torsos unless deadly force would already be justified. Read that carefully. If deadly force isn't justified, those weapons cannot be used. That's a line drawn directly between words and actions. And here's where perception changes permanently. If these restrictions have to be spelled out by a federal court, it implies they weren't being respected on the ground. The ruling quietly suggests that constitutional limits weren't merely stretched, but crossed. And once a court acknowledges that gap, it forces a new question into the open. How many similar encounters never made it into a courtroom at all? Then the pressure starts stacking fast. First, the order itself is temporary, a restraining order that lasts just 14 days. That detail matters because it creates a countdown. Second, the ruling applies only within Judge Simon's jurisdiction in Oregon. It does not bind ICE nationwide. And third, the administration now faces a choice that isn't simple. If it appeals and loses at the circuit level, the ruling could expand across a wider region. If it pushes the case all the way to the Supreme Court and loses there, it risks creating national precedent. That risk alone may explain why this response looks unusually cautious. But there's another possibility raised openly in court. Federal agents could pull back just enough to let the order expire, then resume the same tactics once the clock runs out. That's not speculation pulled from thin air. It's a scenario discussed explicitly because temporary restraint can be a strategy, not a concession. So the situation is unstable. Rights are protected for now, but only conditionally, only briefly, and only in one place. And that leads to the uncomfortable question hanging over everything. What happens if this continues? Now bring this down to where you live, because this isn't really about court filings or jurisdictional maps. It's about what happens when ordinary people show up in public spaces. If you're a journalist, this ruling speaks directly to whether you can stand near a federal building and report without being gassed. If you're a protester, it speaks to whether peaceful assembly comes with physical risk attached. And if you're neither, it still matters, because these encounters don't stay contained. The judge noted that people who were doing nothing more than standing, watching, filming, and speaking were caught up in force meant for threats that didn't exist. Children were exposed. That detail strips away ideology and leaves consequence. You don't need a legal background to understand what that looks like on the ground. Streets closed, air burning, confusion spreading faster than instructions. And once that becomes normal in one city, it quietly becomes possible in others. This is why the ruling resonates beyond Portland. It touches the line between public order and public fear. And if that line feels familiar to you, you're not alone. If this feels like something you've seen before, say so in the comments. This is where the story gets smarter than the headlines. What allows this to happen isn't chaos, it's structure. Federal agencies operate with overlapping authority, broad discretion, and limited immediate accountability. On the street, that creates leverage. Officers control space, timing, and escalation. Protesters and journalists react. Courts arrive later. The incentive system matters too. Aggressive tactics are often justified internally as prevention, deterrence, control. The cost of overreach is usually abstract, delayed, or absorbed by someone else until a judge interrupts the cycle. Judge Simon's language reflects that interruption. He frames the judiciary as a co-equal branch with a duty it may not shirk. That phrase is doing heavy work. It signals that restraint isn't optional and silence isn't neutral. The system relies on courts stepping in when executive power starts testing its own limits. But here's the unsettling insight. The system only corrects after pressure builds, after harm accumulates, after patterns become visible. That means what you're seeing now isn't the beginning of the problem. It's the point where the problem became impossible to ignore. And when systems reach that stage, momentum matters more than intent. From here, the trajectory splits, and neither path is comfortable. One possibility is containment. The administration backs off just enough, lets temporary orders expire, avoids appeals that could widen the impact, and treats each ruling as a local inconvenience rather than a warning. On paper, that keeps everything fragmented. Oregon stays Oregon. Other states fight their own battles. Nothing formally changes nationwide. But the other path is escalation through replication. Attorneys in other states use this ruling as a blueprint. The same briefs, the same arguments, the same language about peaceful protest and excessive force. Judge Simon's 22-page order becomes a template, even if it isn't binding precedent. And as more judges confront the same defendants, the same agencies, the same patterns, the room for denial shrinks. Judges don't operate in isolation from reality. They see videos, they read opinions from other courts. They live in the same society as everyone else. That creates what some call atmospheric precedent, not law on the books, but pressure in the system. And once that pressure builds, the next move stops being reactive. It starts forming in advance. There's one insight that ties this entire story together, and it's easy to miss if you focus only on who won and who lost. This wasn't just a ruling against a tactic. It was a moment where the judiciary openly acknowledged a stress test on the system itself. Judge Simon didn't frame his role as optional or cautious. He framed it as unavoidable. When courts start speaking this directly, it usually means informal guardrails have already failed. In one sentence, the story shifts from enforcement to accountability, from streets to institutions. A democracy doesn't collapse in one dramatic move. It erodes through repetition, through normalization, through the quiet acceptance of things that once would have been unthinkable. This ruling interrupts that rhythm, but it doesn't end it. It raises a question that extends beyond ICE, beyond Portland, beyond this administration. Who steps in when power stops checking itself? That question is already shaping the next cases, the next orders, the next confrontations you haven't seen yet. And if you want to understand where this goes next, before it shows up in a headline, follow the analysis, because this story isn't finished.